Okay, Virginia Life, Annuity Health, statutes and regulations common to all lines of insurance. So one of the first things we need to cover is the structure of the Bureau of Insurance, so you have some idea how it works, and you'll get some questions about it. So we have a woman who's a commissioner of the Bureau of Insurance. I'm supposed to remember her name, but I can't, and I apologize. I just don't remember her name. You can look it up on the Bureau of Insurance website. Just Google Virginia Bureau of Insurance. And by the way, you should get familiar with that website because it'll be helpful to you for a lot of reasons. You should make it a favorite of yours or bookmark it. So the Virginia Bureau of Insurance is the regulatory body that controls the regulation of insurance in the Commonwealth. And as I said to you yesterday or the day before, that each state has its own regulatory body, and Virginia Bureau of Insurance deals with it here. And the person who runs the Bureau of Insurance in Virginia is called a commissioner. It happens to be a lady. And one of the questions you may get on the test is, how does the commissioner get to be the commissioner? And you see it there on the slide. The commissioner gets to be the commissioner by being appointed by what is referred to as a 3-judge panel, which is made up of members of the State Corporation Commission. So she's not appointed by the governor or elected by the people, which is the way it works in some states, but not in Virginia. So that's how the commissioner gets to be the commissioner. That could be a test question. So what is the function here? Well, the function is to execute all the laws relative to insurance, to make sure that any entity or any person that wants a license has a process to be able to do that. And to do that, then she must issue rules and regulations. So you have to read the questions carefully, and I keep saying that, but it's a fact. The commissioner does not enact laws. That's the legislature's job. The commissioner executes the laws by issuing rules and regulations. So one of the questions you may get is, what is it? Can she? I'm sorry, I'm getting stumbled here. Let me just give you the answer. The commissioner can issue any rule or regulation that she thinks is necessary. She doesn't really need anybody's approval to issue rules and regulations. She's supposed to she has hearings, but in the bottom line is she doesn't really have to listen to anybody. It's assumed based upon her position and the fact that she was appointed by some folks that know what they're doing, that she understands what needs to be done. So she can issue any rule or regulation that she thinks is necessary. Now, you and I keep losing people. I don't know what happens, but you and I, as agents, are required to keep records. And the commissioner has some requirements with respect to making sure we do that. So we're going to touch on that. Agents, you and I, are required to keep records for 3 years. Now, people ask, well, what records? Anything to do with your client, anything to do with correspondence to and from, copies of applications, just about anything that relates to your client, you keep that record. You can keep it as a hard file. You should lock it. Or you can keep it on the cloud, as long as it's secure. But you have to keep records. And you have to keep those records for 3 years. Now, my suggestion is you keep them longer than that. Record keeping, your records are the lifeblood of your business. I have rows of file cabinets in my garage. My wife thinks I'm crazy, but I got file cabinets in my garage that go back years. I just am a pack rat when it comes to record keeping. You never know where you're going to need something. So, but the record keeping requirement in Virginia is you must keep your records for 3 years. Insurance companies also have to keep records, and they may ask you about it. Why, I don't know. Insurance companies also have to keep records for 3 years. Now, complaint records, however, have to be kept by insurance companies for 5 years. And a complaint is not a complaint because somebody's screaming at you over the phone. That's somebody who's venting. But usually the complaint shows up to an agent in the form of some written letter or document. That is not for us to deal with. We have to pass that up the chain of command to make sure that that it gets to the home office, because the home office is required to keep those records for 5 years. We do not have the authority as an agent to respond to or handle complaints on our own initiative. The insurance company, once they get a copy of whatever the complaint is, they'll make the decision on how to deal with it. They may tell us what they want us to do, and then we can act, but we don't act on our own initiative. This is up to the insurance company. Now, long-term care insurance. We discussed long-term care insurance. Hold on a minute. We discussed long-term care insurance. And long-term care insurance, as you remember, is the kind of insurance that helps people pay someone to come in and help them when they can no longer live an independent lifestyle. And long-term care insurance there's really two kinds. There's what I refer to as the plain vanilla long-term care, and then one is referred to as a partnership long-term care. And I want to take a moment now to kind of discuss with you, divert the information and talk about partnership long-term care, because you do need to know a little bit about partnership long-term care. What does it mean and what is it? People who have, let me back up. As we discussed yesterday, I think it was, those people who are on Medicaid qualify for long-term care. They get their long-term care needs provided by Medicaid. Of course, they have to go to a nursing home, but Medicaid will provide that. And how do we qualify for Medicaid? Well, we qualify for Medicaid by basically being broke. We have no assets. We have nothing. So I'm hearing some feedback, and I don't know why. I don't see any sound. Anyway, we'll try to fix it that way. Okay. So people who are on Medicaid basically are broke. Well, here's the challenge. People who have money, and I don't have any problem with people who have money. That's not the point here. But people who have money have the ability to hire legal counsel so that they can arrange their affairs in such a way that they have no assets. And if that happens and they need long-term care, then they can go on Medicaid and get long-term care. Well, that's kind of an abuse of the system. And the state's kind of aware of that. There's not much they can do about it. Especially, and the problem with the state is in the general realm, I'm sorry, my mouth is broken this morning. In the general realm of Medicaid, about 65% or so, 65% of the Medicaid budget is spent taking care of senior citizens in nursing homes. And that's a significant part of the budget. So having people able to sneak back into the system who really shouldn't be there is not a good thing, because you and I have to pay for that. I mean, Medicaid is paid for by us. So the state has come up with a system. Virginia is one of a few states that's come up with a system to help incentivize those folks not to do that. And it comes in the form of what we now call long-term care partnership. And what the state has done, the state has entered into partnership arrangements with some long-term care companies that have been around for a long time. They're solid. They're going to pay their bills. They're going to meet their promises. It's not like Lou Cruzati's long-term care company. These are solid companies that have been around for a while. And the partnership kind of works like this. I'm going to paraphrase. The state says, okay, rich guy, we know what you're doing. We don't like it, but there's not much we can do about it. We know what you're doing. But we have a better idea. Rather than you spend literally tens of thousands of dollars with attorneys to basically hide assets, if you will buy a long-term care policy from one of the companies we partner with, here's what we'll let you do. For every dollar's worth of benefit you receive, should you need long-term care, then your long-term care policy will start paying benefits. Well, excuse me. Well, for every dollar of benefit you receive from your long-term care policy, we will allow you to set aside a dollar's worth of assets from the spend down provisions to qualify for Medicaid. Because typically, if somebody has assets and they want to get on Medicaid, they have to use up their assets first. That's the concept of spend down your provision, spend down your assets. So the state says if you buy a long-term care policy from one of the companies we partner with, we will allow you to keep your assets. And then if you need long-term care, your policy will pay. So if you buy a policy, let's say that it's so much a month for so many months, and it turns out to be $2 million over the life of the contract. If you have this policy and you need long-term care, well, your policy will pay your benefit. But at some point, it may run out because you've been alive and the policy is now beyond the benefit period. Well, what we will allow you to do is set aside $2 million worth of your assets from the spend down provisions. You can leave them to your heirs, and then you can qualify for Medicaid. So that's what a partnership plan is. A partnership long-term care policy provides the opportunity for people to maintain assets, but the benefit to society is that it delays their access into Medicaid. And sometimes the individual dies before the policy runs out, so they never have to tap into Medicaid. And I hope you can see this. The idea is to start to slow down that growth of almost 65% of every Medicaid dollar being spent on a senior citizen. So therefore, these partnership plans are unique. You have to have special training to be able to sell them. These plans must also offer what's called, you might want to jot this down, these plans must also offer what is called inflation protection, which means whatever dollar benefit the customer buys has to increase each year by a minimum of 3% so that that benefit keeps pace with the rising costs of care so the policy doesn't run out too quickly. So back to our slide. So insurance companies are required to keep any advertisements that they run to advertise these partnership plans. They have to keep those ads for 4 years. That's what that third bullet is about. Long-term care partnership advertisements must be kept by insurance companies for 4 years. And then training records. Insurance companies are required to keep training records for 5 years. For those of us who sell this long-term care partnership, we have to take special training. And the insurance companies are required to keep those records for 5 years. So if you can see here, the record-keeping requirements are by the year. That's where the question is going to be. How long do you have to keep these records? So if you notice, it's going to be either 3, 4, or 5 years. It's not a challenging thing. So my suggestion to you is, if you get a question about record keeping, very likely the answer is going to be 3 years. The exceptions to that would be long-term care partnership ads, training and complaint records. Training and complaint records have to be kept for 5, long-term care partnership ads for 4. But other than those 2, you can be really sure that if you get a question about how long records have to be kept, the answer is going to be 3 years. Now, the commissioner has certain requirements. And the word shall means there's no wiggle room, right? The commissioner shall is required by law to inspect the books and records of every admitted insurance company once every 5 years. That's a requirement. On the other hand, she may inspect any record anytime. That relates to us. So the commissioner or one of her staff can come into our offices at any time they like during normal business hours and ask to see our records. So we have to keep them and we have to have them available. So again, any record, anytime. That's us. That's a may. She's not required to do that, but she is required to inspect the books and records of every admitted insurance company once every 5 years. Now, penalties. You and I, as insurance producers in Virginia, are held accountable for our actions. We're not like typical politicians who have a tendency to get away with stuff. We're held accountable. So if we violate any law, any rule, regulation, or order of the commissioner, we could be subject to fines, penalties, and even perhaps jail time. So you need to know these numbers. If an agent intentionally violates any rule, regulation, order, or law, the penalty can be up to $5,000 per violation. If we do it unintentionally, then it drops to only $1,000 per violation, and they'll cap any series of violations in the same event, in the same transaction, to $10,000. You need to know those numbers. So the maximum penalty for violating a law or rule or regulation is $5,000 if it's intentional. If it's unintentional, $1,000 with a cap of 10. So for us, ignorance is not an excuse. We have to know what we're doing. And your company will train you. They'll make sure you have knowledge that you need to know what to do. And a lot of it's common sense. Okay? A lot of it's common sense. Also, anyone who tries to sell insurance without a license can be penalized an amount of money equal to the first year commission that would have been earned on that contract. You have to have a license to sell this stuff. That's why you're doing this. So if somebody wants to earn some money selling insurance, they need to do what you're doing. Get a license. Now, if the commissioner suspects that an agent is violating any rule, regulation, law, or order, she will issue a cease and desist order. Right? Stop. Don't do it again. When she does that, she has to give us the opportunity to ask for a hearing. So she has to give us 10 days notice so that we can ask for a hearing. We have a right to defend our actions. Now, during the time that cease and desist order is in effect, the agent is not out of business, but the agent must stop doing the bad thing, so to speak. Knock off what the commissioner is telling you to stop doing. So you're not totally out of business. And a question may go there. You're not totally out of business. You just have to stop doing the activity that the commissioner says stop doing. So I want you to think about this. If an agent gets a cease and desist order and they decide they're not going to pay attention to it, they're going to ignore it, I know you'd consider that to be a violation, and very likely an intentional violation. So here's the penalty now. Let's review that and add some stuff. The penalty is probably going to be $5,000 and or loss of license and or 6 months. Yes, the commissioner does have the authority to put us in jail. Now, understand this. If the commissioner levies a penalty on an agent, it's always going to be classified as a civil penalty, not criminal. There's a distinction. I'm sure you know that. Now, if the commissioner suspects criminal activity, make a note here. If the commissioner suspects criminal activity, she has to refer that to the state attorney general. So everything she does interacting with us is going to be civil, but we can still be put in jail. If we really tick her off and we just thumb our nose and it's a serious violation in her eyes, she can do that. So understand what the penalties might be. The license you're going to get is called an insurance producer license. This is an issue about semantics. When you get your license, it will say Virginia Insurance Producer. It doesn't say agent. Understand what we're saying here. The fact that you have a license to be a producer think about producing premium for insurance companies. You have a license to be a producer, allows you to get hired by an insurance company to become their agent. So we are agents of insurance companies because we have a producer license. That allows us to sell, solicit, negotiate contracts of insurance. It also allows us to receive or share commissions from that activity. Now, I have share commissions in red for a reason. You may share commissions with anyone as long as they have a license similar to yours. You cannot share your commission with anyone who does not have a license similar to yours. So if you have a friend who has a life and annuity license, and they send you they call you up and say, hey, I got a buddy that wants to buy some health insurance. Can you help him? And you say, sure, I can. Well, you can't share your commission with that person because they don't have the health portion of the license. They have to have a license similar to yours. So understand, a license has to be similar to yours. That also applies to going across state lines. If you have a friend in another state that has a life, annuity, and health license, that is not a license similar to yours because yours is a Virginia life, health, and annuity license. So understand how that works. But so you can share commissions with anyone who has a license similar to yours. The license you're going to get is referred to as a Virginia resident license. What are the steps necessary to be qualified, to qualify as a Virginia resident? Some of them are obvious, but there's one or two here that are not so obvious. If you have your principal residence here in Virginia, then you are classified as a Virginia resident. I'm doing all of this, and here we go. Edward, I apologize, my friend. Now you should see the slide. In a second, it should pop in there. Let me know if you see it. Just type in, can you see it? All right, so here we go. It won't hurt to hear it twice. So we're going to talk about Virginia statutes and regulations common to all lines of insurance. Common to all lines. So back to the commissioner. So we have a woman who runs the Bureau of Insurance here in Virginia. Bureau of Insurance is a regulatory body. And how does she get her job? That's one of the questions you may get. She is appointed by what is referred to as a 3-judge panel made up of members of the State Corporation Commission. She's not elected by the people. She's not selected by the governor. The answer to the question, how does she get her job? She's appointed by this 3-judge panel. Now, what's her job? Through the Bureau of Insurance, she's required to execute the laws, license everybody who wants a license, issue rules and regulations. She does not, be careful, she does not enact laws, does she? That's the legislature's job. But she will, in the process of executing the law, issue rules and regulations. So she may issue any rule or regulation that she thinks is necessary. She's not limited here. She can issue any rule or regulation she thinks is necessary. Record keeping. You and I are required to keep records. We have to keep all our records for 3 years. You know, any record relative to your client, applications, correspondence, etc., you're required to keep those records. My suggestion again is keep them longer. That's the lifeblood of your business. Again, you can keep them hard copies, paper copies on files. You can keep them computerized, digitized, but make sure they're secure and you have access to them. Insurance companies also have to keep records for 3 years. But there's a difference now. In complaint records, insurance companies have to keep for 5 years. They have to keep those complaint records for 5 years. Now, and as I said earlier, just to make sure it's clear, however, if you get a phone call from somebody who's screaming at you, that's not a complaint. That's just somebody who's venting. But if you get something in writing, you have to pass it up the chain of command. because it's the insurance company's responsibility to keep a record of those complaints and act on those complaints. They may tell us what to do, but we don't act on our own initiative. We have to follow the insurance company's lead on that. Long-term care partnership. As I said to you, long-term care insurance is really two types. But what I call plain vanilla long-term care and partnership plans. And I'm going to briefly go over it again just to make sure it ties to what you see on the screen. So people who are on Medicaid get there because they have no assets. They're broke. And about 65% of every Medicaid dollar is spent to take care of a senior citizen in a nursing home. And what's happened over the years is that people who have a lot of money are able to hire legal counsel to hide their assets, so to speak. Because you see, before you can go on Medicaid, if you have anything, you have to spend it down. You have to get rid of it. Then you basically have to go broke. So they hide their assets, so they don't have any assets, and they go on Medicaid. Well, that's kind of an abuse of the system. So the state is not like that. So they've come up with this plan, so to speak, this deal, and they've made arrangements with certain long-term care companies, solid, well-respected, well-known companies, to offer these special kind of plans. And if a rich person, I shouldn't only pick on rich people, but people who have money buy one of these plans, the state will basically say what? Hey, look, guy, we know what you're doing, but we don't want you to hide your assets and just jump on Medicaid. That hurts the citizens of the state. So what we want you to do, we'll make it easier for you. Instead of spending tens of thousands of dollars with an attorney, buy a long-term care partnership plan from one of the companies we partner with. Now understand, the state doesn't make any money on this. It's not like they're an agent, but the state saves money through Medicaid by delaying people's access into Medicaid. And how does that work? Well, that works this way. When a person buys a policy, long-term care policy referred to as a partnership plan, for every dollar's worth of benefit they receive, should they need long-term care, that will allow them to automatically set aside a dollar's worth of assets from the spend down provisions. So they can keep those assets, pass them on to their heirs, and if they exhaust their long-term care policy, they can then apply and get Medicaid, and Medicaid will take care of their long-term care needs. The value to the state is it delays their access into Medicaid, and in many cases, they die before they get there. So that's a partnership plan. And partnership plans also are required to offer what's called inflation protection, where the benefit they buy must increase each year by a minimum of 3% to keep that benefit in line with the rising costs, so the benefit doesn't exhaust any quicker than it has to. So you need to know that if an insurance company wants to run an advertisement for these long-term care partnership policies, then they have to keep that ad for 4 years. Training records, those of us that sell this stuff, these partnership plans, have to take special classes. So the insurance companies are required to keep those training records for 5 years. So as I said earlier, when you get questions about record keeping, it's mostly going to revolve around how long a record has to be kept. And the best way I can suggest to you is focus on the idea that if you don't know the answer, 3 years will be your answer. The exceptions are what you should lock into. The only exception that I know of to the 3-year rule about record keeping is long-term care partnership ads, 4 years, training and complaint records, 5 years. If you hold on to the exception, the rest will fall into place for you. Now, the commissioner is required by law, that's what the word shall means, right? She is required by law to inspect the books and records of every admitted company once every 5 years. She may, and very often does, inspect any record anytime. That's us. She can inspect any of our records anytime. If she or one of her staff walks into our office and says, we want to see your records, you can't say, I'm busy, come back tomorrow. She has to be allowed to see those records. That's why they have to be accessible. Now, any record anytime doesn't mean 4 o'clock in the morning at McDonald's. Normal business hours, okay? And as we said earlier, we're held accountable for our actions. So if we violate rules, we're penalized. If we intentionally violate any rule, regulation, or order, that's a $5,000, up to $5,000 per violation. That's serious. If we do it unintentionally, the penalty drops to $1,000 per violation with a cap of 10 with any series of violations in the same transaction. It's still pretty serious. Nobody wants to come up with that kind of money. So ignorance is not an excuse for us. You got to have a license to sell insurance. So anyone who tries to sell insurance without a license is going to be penalized an amount of money equal to the first year commission. That may show up on your test. Now, the commissioner, if she believes an agent is violating any rule or regulation or order, she will issue a cease and desist order. Stop, don't do it again. She's got to give us 10 days notice. We have a right to have a hearing. So she's got to give us 10 days notice so we can ask for a hearing. We have a right to defend our action. But the cease and desist order doesn't mean we're out of business. It just means we have to knock off what she tells us to stop doing. So be careful. We're not out of business. Just knock off the stuff she tells us to do, not to do. Now, some agents get real testy and say, the heck with you, commish, I'm going to do it anyway. So that would be an intentional violation. And the penalty is going to be $5,000 and or loss of license and or 6 months. And that's not 6 months in Tahiti. That's 6 months in jail. The commissioner, as I said, has the authority to do that. But these are all civil, right? Civil penalties, not criminal. If she suspects criminal activity, make sure you have a note here. She has to refer that to the Attorney General because that's the AG's job. The license you're going to get is that of a producer. It's the license. It doesn't say Virginia agent. It says Virginia insurance producer. That allows you to get hired by an insurance company to become their agent. The term we use is you get appointed by the insurance company. So in our vernacular, in our language, we use the word appoint, A-P-P-O-I-N-T. We get appointed to become an agent. In the rest of the world, they call that getting hired, okay? That allows us to sell, solicit, and negotiate contracts of insurance. And I went through this thing about sharing commissions. You can share commissions with anyone as long as they have, remember, as long as they have a license similar to yours. The license you're going to get is a resident license. What does it mean to be a resident? How do you qualify to be a resident? And as I said, some of these are obvious, a couple of them are not. So if your principal residence is here in Virginia, that would qualify you to get a Virginia resident insurance license. However, if you happen to be here, let's say in the military, and you file your taxes while you're here in Virginia and you use a Virginia address, which happens often, that would also qualify that person as a Virginia resident for the purposes of getting the Virginia insurance license. Or if they work a part-time job while they're here, they earn income and pay Virginia income tax, that would also qualify them as a Virginia resident. And the last one, if a person's principal place of business is in Virginia. Now, that does not apply to someone who's in California who wants to open an office in Virginia. This applies to what I refer to as the border cities. There's some cities in Virginia that actually border two states, like Bristol. If you're familiar with Bristol, you know that someone could actually live in Bristol, Tennessee, and they could have an office almost across the street, and it'd be in Bristol, Virginia. This is what they're talking about here. So we have an individual who fits that situation. They live in Bristol, Tennessee, but they have an office across the street in Bristol, Virginia. That would qualify them as a Virginia resident for the purpose of getting the license. Okay? They actually have an option. They could get a Tennessee resident license and a Virginia non-resident, or vice versa. But that's the exception about the principal place of business, of those border cities. So the license you're going to get has no expiration date. When you get it, you'll see there's no place on it will there be an expiration date. There will be an issue date, but no expiration date. So we refer to the license as perpetual. It doesn't expire in the same way your driver's license expires. Your driver's license has a specific date upon which it expires, and you must renew it. Well, that doesn't happen in the insurance business, in our license process. Our license is perpetual, so we don't have to renew it in the same sense we renew our driver's license, for example. But we have to maintain it. This becomes an issue of semantics, understanding what they're trying to say to you. We have to maintain our license. How do we maintain our license? Well, one way is we must complete certain continuing education courses every 2 years. We must pay what's called a continuance fee. Might jot this down. The continuance fee is $20. Every 2 years, you have to pay $20 to maintain your license, in addition to doing certain continuing education requirements. And we're going to get to the hours in a minute. And that's what you have to do. Oh, and keep your nose clean. Right? Don't get convicted of a felony. Right? But as long as you keep your nose clean, complete the required continuing education course requirements, and pay your continuance fee, your license is golden. You're not required to be appointed by an insurance company to maintain your license. If you decide, for whatever reason, you want to go on a hiatus and not work for anybody for a while and give up all of your appointments, you can do that. Your license remains valid as long as you do the required CE hours and pay your continuance fee. So what does it take to qualify to become an insurance agent in Virginia or insurance producer? Well, you got to be at least 18. You have to be a resident. We've already gone over what it takes to be a resident. You have to pass a test. Unfortunately, it doesn't say take a test, does it? You got to pass this test 70% or better. Then once you pass the test, this could be a test question. Once you pass your test, you have to make a written application to get your license within 183 days of passing the test. Now, nobody waits that long, but that's the requirement. If you don't get it done within 183 days, you got to take the test over. Now, use some common sense here, ladies and gentlemen. 183 days is equivalent to 6 months. So don't quibble over on the test if they don't say 183 days, but instead they say 6 months. Fine, that'll be your answer. And sometimes they'll use 180 days. That's basically the same time frame. Don't get all hung up on the exact number. It's either 183, 180, or 6 months. Any one of them will be correct or interchangeable. However, caution, if you get a question, 4 choices, and 3 of those choices, 183, 180, and 6 months, reread the question, because it's probably going to be what's not true, right? None of the above or all of the above is probably going to be the answer, because no one of them is more correct than the other. Now, initially, to get your license is $15. The continuance fee is $20. And that $15, I got a feeling, is going to change. Then you have to have a background check. And the process that you're going through with a company that you're going to go on board with is already processing that background check. Part of the fees you paid took care of that. By the way, that's a Virginia State Police background check. Now, there's another license that exists in the Commonwealth. I don't know anyone who has one, but it still seems to show up on a test. It's called a consultant license. So a consultant, as you can imagine, is someone who gets paid to give advice. Separate license, separate test. However, this is where it gets stupid, in my opinion. If someone has a life, annuity, or a health license, they may act as a consultant and they don't have to take that test. So for the person like you, when you get your license, you'll be life, annuity, and health license, you may act as a consultant. You don't have to take that separate test. So you need to be aware of that. You may get a question about it. But there's a problem here. You can't do both. You may not act as a producer, agent for an insurance company, and at the same time be a consultant. Only one or the other. And frankly, in all my years in this industry, the bigger long-term reward monetarily is as an agent for an insurance company, not as a consultant. Business entity. Question, can a business get a license? The answer is yes, but obviously the business can't sit for the test. So question, how does a business get a license? Well, it gets a license that is the same license as the owner of the business. So for example, if I want to start a little agency and I want to call it You Brigham I Rip'em Insurance Agency, or Dewey Cheatham and Howe Insurance Agency, I can do that. That's now a fictitious business name. I have to get that fictitious business name approved by the Commonwealth before I can use it. But if I can get it approved, then I can ask the Bureau of Insurance to issue a license to my business that is similar to mine. Why would I do that? Well, I might prefer, if I get the insurance company to agree with me, to have my commissions paid to my business rather than to me personally. Some agents do that. Not a big deal, but it may be a test question. So can a business get a license? Yeah. How do they get the license? The owner of the business applies to get that license for the business. It has to be the same license as the owner, and any fictitious business name has to be approved by the Commonwealth. Now, if you use your own name, referred to as your bona fide natural name, like Lou Crissati Insurance Agency, I don't need anybody's approval. I don't need to get approval to use that because that's not a fictitious name. But I still would have to get my Lou Crissati Insurance Agency business license to have it earn a commission. Understand how that works. Now, there are circumstances where the state will allow a temporary license to be issued. A temporary license to be issued. The temporary license is only good for 6 months, 183 or 180. That fits here as well. And only one temporary license per person per lifetime. They don't want somebody to get temporary licenses back to back because you don't have to take a test to get a temporary license. What would provide the opportunity for somebody to get a temporary license? Well, if an agent dies, gets disabled and can no longer work, is in the military and deployed overseas, or if they're a debit agent, and we're going to talk about that in a second, then, as a matter of fact, let's forget debit agent for a minute. If an agent dies, gets disabled, or is deployed, then their spouse, next of kin, personal representative may immediately apply to the state to get a temporary license until such time as they can get their permanent license, or find an agent to take over the business, or whatever, or come back from when the military person comes back from overseas. So it's temporary. Now, a debit agent also can have a temporary license. What's a debit agent? A debit agent is an individual who basically goes door to door collecting insurance premium, much like a bread route. Now, I'm not trying to denigrate bread routes and milk routes, but an agent gets a book. They work for a company, and these policies are small burial policies usually, and their premium is collected in person by the agent on a monthly basis. So this agent walks around door to door collecting these premiums in person on a monthly basis. They also use that opportunity, hopefully, to sell insurance. So the debit agent may also get a temporary license so that they can go around and collect the money, because you have to be an agent to collect the money, while they're preparing to take the test so that they can sell insurance. So debit agents can also get temporary licenses. Now, there may be a test question about which of the following does not need an insurance license. Well, I'm going to try to make this paragraph, as simple as I can. People who are in the insurance business do not need a license if they do not help others make decisions about what to buy and earn a commission. So who might that be? An officer of an insurance company, customer service people. There's lots of folks who interact with customers that work for insurance companies that don't have to have licenses. But when you sit down with somebody or are on the phone with somebody and you are helping them make decisions about what to buy, and you earn a commission, now you need a license. Before we get into continuing education, I want to take a quick break because, first of all, I need to, and I want you to be somewhat fresh for this continuing education process. So we're going to take a break here for about, I'm sorry, let's make sure we get this. So by midnight, 11:30 of the even-numbered biennium, you have to have it done. If you don't get it done by then, you basically have to take the test over. They do give you a grace period, as I said, till 12/31, but 11/30 of the even-numbered year. If you have one license, you got to do 16 hours. Of those 16 hours, 8 needs to be relative to the license you take. So as I said, you have life, annuity, and health. You have a wide array of choices to pick from. Any one of them will do. 5 of the 16 hours can be in any discipline you like. Now, most people don't go outside their license, okay? I mean, you could take a course in auto, but not a good idea. So try to keep within the realm of what you do. However, 3 of those hours, 3 of those 16 must be in what are called Virginia law and regulation, and that totals 16 hours. Now, you may take those courses in a number of ways. You can go online and do an online course. You can do a home study course, or you can do live classes. But those courses must be provided, or you must take those courses by an approved, Virginia-approved continuing education provider. You just can't go read a book somewhere. Now, this is a blatant advertisement for American Academy. So American Academy for Insurance Training is an approved continuing education provider in Virginia. And we do continuing education courses. We do them live. The difference between live and online and home study is this. With online and home study, you have to take a test and pass it with a 70% score. Closed book test, they have a way of doing that. Sometimes you have to take a proctored closed book exam, pass it with a 70% score. If you go to a live class, there's no test, just getting through the day. Now, there is a difference in cost. These online courses are generally less, but the live course is not that expensive either. I've been working with Ruth for a very long time. She and I have a great business relationship, and she has allowed me over the years to come into her region, and we pick a weekend somewhere around September or so of the even-numbered year, and we set up shop, and we come into an office, or maybe we come into 2 offices depending upon where they are, and we'll do these continuing education courses and get them done for you over the weekend. We generally don't charge more than about $89. They're not that expensive. But it's your call. You're not required to do any of that, but you are required to get it done. How you get it done is your call. But I would be an idiot if I didn't bring it up and let you know that we offer that, and we'd welcome to see you in our CE classes in the future. All right, so that's the rule. You need to know 16 hours. Of those, 8, then 5, and the most important data here is 16 hours, 3 in Virginia law and regulation. Now, if someone has 2 or more licenses, then you got to pick up an extra 8 hour. What would be a second license? Well, property and casualty would be a different license. So if we had life, annuity, and health, that's 1 license. And we had a property and casualty license, that would be 2. It doesn't double. You just need another 8 hours in that specialty. So any agent holds a life annuity, because that's a license, or a health agent license, that's a license, or both, shall complete 16 hours of relevant continuing education credits. This is a dumb question. It sometimes shows up on the test, and it's a little confusing. And here's the way I try to explain it. Virginia is one of the only places I know where 1 and 1 is 1. You see, there are 3 ways, 3 different tests to get a license similar to what you're trying to get. There are some folks that just sit for the life and annuity license. They just want to take that test. That's a 100-question test. There are some people that just sit for the health license. That's a separate test, 100 questions. But I think it's wiser to take a combined life annuity and health license. But the state says, even though life and annuity is a license and health is a license, well, where I come from, that would be 2. No, they say what? The old life and annuity or health or both, which you guys are going to have, 16 hours. So you guys have to have 16 hours done. So here's an example of a typical question. John has a life and annuity license. His wife has a health license. How many hours of CE credits do they need? I'm going to give you a second here to look at it. But I'm going to give you the answer. The answer is, I know everybody guesses that. Thank you for playing. 32. Here's what you missed. They need 32. I know that's unfair, huh? But that's what they do. That's why you have to. That's why you have to pay attention. Ed. I'm not trying to trick you. I'm just trying to get you aware. Okay. So it didn't say how much does he or she need, right? I know you see it now, and that's the kind of stuff they do. You were right. He needs, she needs, but they need 32. Okay. So let's take it a step further. I don't think you're going to mess it up this time. So he has life and annuity. His wife has property, casualty, and health. Now they're going to need 40 hours. I think you see that. Okay. Weird, huh? But that's the kind of crazy stuff. So you know it, but if you misread that question, that's the value of going online and doing those practice tests over and over and over, okay? That's the value of doing that. Also, no more than 75% of those total required hours can come from a company or agency-sponsored course. There will be times that you may get a phone call from management that says, hey, if you come to this meeting, we will provide you as part of your attendance 1, 2, 3 hours of CE course credits. That's fine. That's a company-sponsored or agency-sponsored course. That's fine. But no more than 75% can come from that environment. They want at least 25% to come from some outside, unaffiliated provider, like American Academy for Insurance Training, okay? Again, you have to have it completed by 11:30. And if you don't get it done when you're supposed to, this is the answer to the question. If you don't get it done when you're supposed to, your license is terminated. And the only way to get your license back once it's terminated is to retake the test. It's a lot easier to get it done on time. And frankly, there's no excuse not to get it done, because every 2 years, the state sends out a letter to every producer who's required to get it done that year, and the letter starts out kind of like this. You have failed to comply with the requirements for continuing education. Failure to comply result in loss of license, burn down your house, take away your kids, and shoot you in the head. Then they scare you, okay? So no excuse. People ignore those letters, but you shouldn't ignore those letters. They're done to remind you. As I said earlier, some people get a waiver. If you're really, really sick, you can apply for and will very likely get a waiver. If you're overseas in the military, you'll get a waiver. But when you get better or come back stateside, you got to catch up. Some are exempt. So anyone licensed during the last 12 months of the biennium is exempt from the current biennium. You will be licensed for the full biennium. So you're going to have it done by 11:30 of next year. Warning, Will Rogers, danger, Will Rogers, caution. Do not do any continuing education courses until you got your license in your hand, okay? Now, some people say, well, why did I do that? Well, some people want to get a head start. Don't. The continuing education course will not count unless you have a license in your hand, okay? Also, consultants, those people who have that consultant license, sometimes I believe, I don't know anybody personally, but it would seem to me when somebody gets a consultant license, they realize they can't make much money, so they'll go ahead and get an agent license, a producer license, so they act as an agent. So now they're an agent and a consultant, they have 2 licenses. Well, if they have one or the other, they only need to do 1 set of CE courses. They're not required to do 2. This one shows up on the test often. Anyone 65 or older by the end of the biennium, if you've held a license for at least the last 20 years, with 4 in Virginia, may apply for an exemption. You aren't going to have to worry about that for a while, but you might see it on a test. Also, non-resident agents who satisfied their resident state requirements. For example, I'm non-resident licensed in about 8 states. If I had to do CEs for each state, I'd be doing continuing education 24/7, 365. So there's reciprocity among the states. Remember, we talked about the National Association of Insurance Commissioners, and they create model laws. Well, one of the model laws they've created is this reciprocity agreement among states, that as long as you complete your resident state requirements, you're not required to do the requirements of your non-resident licensed states. Pretty cool stuff. If you change your address, you got to notify the commissioner within 30 days. I haven't seen an application for a while, but my recollection is on that application, there's a place for you to put down 3 addresses. They can all be the same or they can all be different. One is a home address, one is a mailing address, one is an office address. A mailing address, a home or an office address must be a physical location. You can use a P.O. box as a mailing address. But regardless of all that, if any of those addresses change, you got to notify the commissioner within 30 days. If you move out of Virginia, there's a question about moving out of Virginia. So if a person moves out of Virginia, their license is terminated. The minute they drive across the state line, moving to the new state, their Virginia license is terminated, even if they don't notify the commissioner. It's an administrative termination. It automatically happens. People say, well, my God, what do I do? Well, here's what you do. You plan it. Moving is generally a planned event. We don't normally wake up Tuesday morning and say, okay, kids, we're moving to Arkansas. It's generally a planned event. So you plan it. You contact the state you're going to move to. All you have to do is go online, fill out a form, and pay them a fee, and you'll get a non-resident license in that state. Once you leave Virginia, as you drive across the state line, your Virginia license will be terminated, but you have your non-resident license in this new state. When you get there, all you have to do is make a switch. Contact your new state and say, I'm now a resident, and they'll very likely just maybe charge you a small fee and flip you back to a resident agent. And then you, if you want, can call Virginia, contact them, and become a non-resident in Virginia. It's an easy process. Just plan it. However, on the test, if you move out of Virginia, license is terminated, even if you don't notify the commissioner. Now, licenses can be suspended, revoked, or denied for a ton of reasons. Get caught cheating on a test. Forge names to paperwork. These are pretty obvious stuff. But the biggest question, the biggest problem we have with these questions is the difference between an indictment and a conviction. See, you will lose your license if you're convicted of a felony. You won't be able to get a license if you've been convicted of a felony. But if you've been indicted, that has no bearing on it. So there's a difference between being indicted and being convicted, which goes back to what I keep saying, make sure you read the question. If John's been indicted for a felony, nothing happens. If John has been convicted of a felony, he'll probably lose his license. He has to notify the commissioner within 30 days of the conviction, and then he will lose his license. If he applies for a license after having been convicted of a felony, they very often will deny that license. Now, there's an appeal process. Not everybody is permanently denied. There are exceptions. I'm not going to get into that. But my point here is, remember the difference. Be aware of the difference between indictment and conviction. You don't lose your license or get it suspended or revoked because you've been indicted. And if a person's license has been denied or revoked, if they want it back, they got to wait 5 years before reapplying. Test question. Agents got to be licensed at the time of the sale to earn a commission. I think that makes sense. However, in your activities, you are going to be earning renewal commissions. So once you make a sale, you get paid initially, and then they have a system. I'm sure they do. They have a compensation package, which is very generous, and you'll be able to continue to earn commissions as long as that business stays on the books. That's called a renewal commission. You do not, under the law of Virginia, you do not have to maintain your license to continue to get your renewal commissions, as long as you are vested in them. Make sure you make a note. As long as you are vested in them. In other words, as long as you own them. And that's a matter of the contract you've signed with the insurance company you work with. And as we've said, you got to be licensed, so companies can only pay commissions to properly licensed agents. Now, there is a question that shows up about administrative fees. And as you can see, agents can charge administrative fees. What's an administrative fee? Let's try to make this clear. Let's assume you're sitting in your office and a customer comes in and says, I want to buy some insurance. And you say, great, I charge $20 to fill out the paperwork. That would be an administrative fee. So if you want to charge an administrative fee, you have to have a schedule of those fees posted so the public can see it. And you must get the customer to sign a copy of the fee schedule. Now, nowhere in that paragraph, that bullet, does it say you have to give them a copy. I want you to think back to earlier this morning. Record keeping. You must keep records for how long? 3 years. So why do we have the customer sign a copy of the fee schedule? So you keep that for 3 years. You are required to keep it for 3 years. You are not required to give them a copy of the signed fee schedule. Now, would I? Of course I would. But the test isn't about what you might do. It's about what you have to do. So we can charge administrative fees, but we must have those schedule of fees posted. And if the client has to sign a copy of that fee schedule, and we must keep that for 3 years. Once again, if you're convicted of a felony, you got to notify the commissioner within 30 days. Why notify the commissioner? Well, here's the reason why. If you don't notify them, you're probably never going to get your license back because they're going to find out. If you notify them in 5 years, if you choose, you might get your license back. Marketing practices. There are certain things we got to be cautious about because the law says we got to be careful. First of all, rebating. Rebating is illegal. Rebating is basically bribing someone to do business with you. You can't do that. Both the offer and the acceptance of a rebate is illegal. So now there are exceptions, calendars and postcards and some kind of advertising document, a trinket for like a key ring. That's different. But if you give a customer a gift certificate to go to dinner, that could be called rebating. If you give a customer tickets to go to a ball game, that could be rebating. If you go with them, that's not rebating. That's not on your test. I'm just letting you know. So if I take my customer with me to a ball game, that's not rebating. If I send them to the ball game, that could be rebating. So for your test, anything of value could be rebating. The exclusions are trinkets, okay? Pens, magnets for a refrigerator, stuff like that. Misrepresentation. Well, you and I got to be really careful. Because if we make any misrepresentation, we could lose our license. We're not allowed to lie. We got to be straightforward, honest, etc. Defamation. I used to work for a guy. He never got out of the 8th grade. He was worth like $150 million when I met him. Amazing man. Anyhow, he had these country sayings because he was from Marion, South Carolina. And he had these country sayings. And he'd say, whenever you throw dirt, some of it gets on you. Well, that's the way it works. Don't be talking trash about other companies or other agents in the business. First of all, it's illegal. Second of all, that's not a cool thing. It reflects badly on a person who says it. I think you know that. False advertising. I know you know that false advertising is illegal. That doesn't take a rocket scientist to figure out. But here's the deal. They're looking for something specific on this question. We have to be careful of how we identify the policy we're selling the customer. And they utilize these two most often. A charter policy. You can't call the policy you're selling this customer a charter policy, because that would imply to the customer that there's something special. Because a charter member of an organization is only a specific group. Only so many people can be the charter member of anything. So if we say this is a charter policy, that would imply that they're special. Well, they are special, but anybody who wants that daggone policy can have it. So be careful. Also, on the life side, can't call a life insurance policy an investment contract. Can't use that word investment when it comes to any life insurance product. There's a life insurance policy, so watch for when we use those terms. Also, we're not allowed to boycott, coerce, or intimidate. I don't think you're going to have problems figuring that out. But the concept of coercion, I want to make sure this is clear. Earlier in our process, I said to you that a bank can require as a condition of a loan that you have insurance. That is not coercion. It becomes coercion if they require you buy it from a specific agent or company. So understand what we're saying here. It's not illegal to have the requirement that you have to have the insurance to get the loan, but it is coercion if they make you buy it from their best friend, okay? Discrimination, ugly word. That word has been beat up so bad in our society lately that it's lost its impact. I want to puke, pardon the expression, every time I hear discrimination. People have no idea what they're talking about. They think they do, but they don't. Because discrimination sometimes is a smart thing. Not all discrimination is bad. For example, we don't want to eat poison, so we are discriminating about what we're going to eat. Okay? So how we use the word is important. Now, in our world, we may discriminate against people that in the real world we cannot. Example, in the real world, you can't discriminate against someone because of their age. We do it in insurance all the time because old people pay more for the same thing that young people pay. In the real world, we cannot discriminate against someone because of their gender. In insurance, we do that, especially in life insurance. Men will pay a higher premium for life insurance than a woman of the exact same age buying the exact same policy. Women will pay less. That is discriminatory against men. That could be perceived as that. But the reason they do that is that women live longer than men. Men die faster. It's a matter of statistics. It's not because they're trying to be mean. So we developed this list. I call it a taboo list. Insurance companies may never, 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 ever discriminate against anyone based upon those items: race, religion, color, creed, national origin, sexual preference, or domestic violence. Insurance companies cannot discriminate against anyone for any of those reasons. Even if they could prove Italians live longer than Frenchmen, they can't charge a Frenchman more money for the insurance. Making my point. Domestic violence is a fairly new addition. Insurance companies in the past did not want to insure women, especially who are involved in relationships where there was violence. Why? Because they got hurt a lot. Doctor bills. Sometimes they died. Death benefits. Well, laws have been passed and they can no longer do that. So just understand my taboo list. That's a no-no for insurance companies. But I want to draw your attention to something. What is not up there? What is not there is marital status, whether you're married or not. Insurance companies may discriminate against someone based upon their marital status. They don't often do it. Matter of fact, the only time I see it done is in auto insurance. A young man usually under the age of 25, who's single, will pay more for their auto insurance premium than a man of the same age who's married. They just feel they're more responsible, I guess, whatever the reason. So marital status, you may get this on your test. Insurance companies may discriminate against someone based upon their marital status. Okay. Twisting. Twisting is illegal. When I was a young man, there was a dance called the twist. My parents used to think that was illegal. If my parents saw what goes on some of the dance floors today, they'd be spinning in their graves. Oh, God. I was with some friends of mine a couple of months ago. We went out to a place, and I looked out on the dance floor. I said, what are they doing out there? He said, they're dancing. I said, they're dancing? They need to get a room. Some of that stuff. And then I realized I was being a little judgmental, kind of like my parents. So I kind of shut up. But anyway, we're not talking about dancing here. Twisting. What is twisting? Here's your definition. Twisting is when you and I, as agents, lie to someone to induce them to lapse, cancel, surrender, or switch a policy. See, if we have to lie to them to do it, it's probably not in their best interests. It is not illegal to induce someone to lapse, cancel, surrender a policy. Because if you tell them the truth, if you lay the cards on the table, it might be in their best interests. So that's why I've worded it the way I've worded it. Twisting is misrepresenting to their detriment. Okay? Because if you have to lie, it's probably not in their best interest. That's twisting, and twisting is illegal. Now, the Virginia Insurance Guarantee Association. If you and I formed an organization that does what this does, and we use that name, we use the word guarantee in it, they throw us in jail for fraud. Because I'm fairly convinced that if you had a document in front of you that had the word guarantee on it, you would have some expectation that if something went wrong, you would be made whole again. Well, this Guarantee Association doesn't do that. I want you to consider as we go through this, the Guarantee Association is more of a safety net than a guarantee. The actual official title is the Virginia Life Accident and Sickness Guarantee Association. That's its official title. And every insurance company who wants to be admitted to do business in this state must belong to this association. And the reason the association exists is in front of you. To protect the public when an insurance company becomes insolvent, they can't pay their claims. So the state will, this association will step to the plate, but it's not going to guarantee them they're going to be made whole again. It's more of a safety net. You'll see what I mean in a minute. The maximum benefit that the Guarantee Association will pay on any one life is $300,000. So listen to this question I'm going to pose to you. Mary has 10 life insurance policies on her husband. He dies. What is the most amount of money she could expect to collect from the Guarantee Association? $300,000. Doesn't matter, based upon that question, how much life insurance he has. None of that matters. The question is very simply, what is the most she could expect to get from the Guarantee Association? That's the heart of that question. And that number is $300,000. Now, we have cash value policies. In life insurance, we talked about cash value policies. So if a company goes bankrupt and I've got a policy that's got $200,000 in cash in it, I'll be lucky to get $100,000 from the Guarantee Association. Now, let me set your mind at ease here. Have you ever heard the word insurance-rupt? The answer, probably no. Have you ever heard the word bankrupt? Answer, probably yes. Insurance companies don't go belly up, generally speaking. In my lifetime, I am aware of maybe 2 insurance companies that have ever gone bankrupt to the point that their policyholders had to turn to the association. So it rarely happens. So it's not, insurance companies are the most highly regulated companies in the world. They're regulated greater than any other industry because they're regulated by the state. And the closer the regulator is to those being regulated, the more effective it is. When we had that financial meltdown a few years ago, insurance companies did not have any problems. There were the investment companies that had problems. Some of those companies had names that sounded like insurance companies, but it was their investment side, not the insurance side. Because, and this is not for your test, this is just for your peace of mind. For every dollar of promise an insurance company makes, they must have a certain amount of money in reserve, liquid money, to pay those claims. They're governed by the state. They have what are called reserve requirements. They have to have so much in reserve for every dollar's worth of benefit they're making promises to pay. So they're in great shape, I promise you. But you need to be aware of the Guarantee Association. Also, you and I cannot discuss with our clients the fact that this Guarantee Association exists. Insurance companies cannot advertise the fact that they are part of the Guarantee Association. Of course, the state says that in their inimitable wisdom that if we do that, it would imply to the consumer that our company has a guarantee that another company does not, which is not true, because every company that wants to be admitted to do business in Virginia must belong to the association. Now, what I don't have on the slide, I want you to think about this and maybe jot down some notes. So where does the money come from for this association? It comes from what's called a premium tax. Every admitted company has to charge the client a premium tax. So the premium we pay for any insurance policy that we have, embedded in that premium is this premium tax. And when the insurance company gets the premium from us, they have to take that tax and submit it to the association. That's the funding mechanism for the association. It's funded by the premium tax. And it works a lot like the sales tax retailers have to pay the Sales Tax Bureau. It gets transmitted, so it's there. So how does the association get funded? A premium tax. Every admitted company must participate in that. The idea is the company that sells the most insurance has the most money in the association. But we can't discuss it. They don't trust us how to explain to a customer how a guarantee is not a guarantee. So if you happen to be the only agent in the history of man that has a customer ask, what is this thing about the Guarantee Association? You give them the phone number for the Bureau of Insurance. Don't get involved in the conversation. We're not allowed to discuss it. I've been licensed in a number of states. Every state has a similar rule. I have never had a customer ask me about it. We've already discussed this idea of adverse underwriting. Remember, the risk selection process, we, the agent, are called the field underwriter. This is just a quick review. The home office underwriter is responsible to protect the company from adverse selection. Remember, they select, classify, and rate risks. We've been through that. Now, I'm going to email you a document. And the title of the document is going to be Numbers, Dollars, Days, and Dates. And that document is going to include the most important numbers, dollars, days, and dates you need to know to pass this section of the test. That'll be very helpful to you. So watch your email for this email document, numbers, dollars, days, and dates. If you don't get it by tomorrow, text me and let me know. But that's going to be a big help to you. 80% of what you need to know is going to be on that document. So we are going to take another quick break. We're going to pick up with Virginia Life, and then we have to do Virginia Health. Maybe we'll do Virginia Health first, Virginia Life, I don't know. And these are short, maybe 17 to 20 slides, and then we'll be done. So we'll be back here in a few minutes. Take about 10 minutes. I'll be right back. percent.